everybody for being here. My name is Yolanda Fair, and I'm one of the assistant juvenile defenders with the Office of the Juvenile Defender. And this is our monthly virtual series. And today we're excited to have Dr. Coons and Dr. Cochran speak to us about the new capacity law and the procedures that are related to those, and just some of the things that they're seeing in their respective roles in the field. I will introduce them and then I'll turn it over to them. If you have any questions, please feel free to put those in the chat. We will be monitoring the chat, and if it's a question that's about something they're talking about on the slide, I will interject and ask the question to our presenters, but they will also have a question and answer session at the end of the session. So I'll go ahead and introduce them. So Dr. Peter Coons is the Director of Facilities and Programs with the North Carolina Division of Juvenile Justice. He spent his past 20 years working as a psychologist with both adjudicated juveniles and incarcerated adults. He began his career in 2003 working as a substance use therapist at C.A. Dillon Youth, and then remained there for the next 7 years, serving as both a staff and senior psychologist. In 2010, he transferred to the adult correction system when he took the position as a psychological program manager for inpatient mental health at Central Prison located in Raleigh. In late 2012, he transferred to the position of psychological program manager for the outpatient program at Central Prison, where he both oversaw the clinical operations of the prison and provided direct therapy services to the general population, restrictive housing, and death row units. In 2017, he returned to juvenile justice, where he served as the clinical director for the Lenore Youth Development Center, and accepted his current position just recently. Dr. Coons is a licensed psychologist and received his doctorate from Forest Institute located in Springfield, Missouri. He lives in Durham with his wife and 2 children. Thank you so much for being here today, Dr. Coons. And then we also have Dr. Robert Cochran, who is originally from Northeast Ohio. He completed his doctoral degree at Wright State University in Dayton, Ohio, and a postdoctoral fellowship in forensic psychology at the University of Massachusetts Medical School in Worcester. He retired from the Federal Bureau of Prisons after 21 years, during which time he was the internship training director and forensic evaluator at the Federal Correctional Complex in Butner, North Carolina. He then served as a training director for the North Carolina Department of Public Safety, leading the internship programs and developing the continuing education curriculum. He has been in practice in North Carolina for 25 years and currently oversees the planning and implementation of the forensic services in North Carolina at DHHS. He is a board-certified forensic psychology. He is board-certified in forensic psychology and a member of the American Board of Professional Psychology. He is also a member of the American Psychology Law Society, the NCPA, past president of the American Academy of Forensic Psychology, and a board member in examination faculty for several years for the American Board of Forensic Psychology. Thank you so much for being with us today, Dr. Cochran, and I will turn it over to you both.
Thanks, and I'll get started. Thanks, Yolanda. I just realized we gave you too much, or I gave you too much of my bio. All that didn't need to be read. Peter's got an impressive background, and I like hearing about him, but we got to cut that down next time.
Right, yeah.
But anyway, I'm going to share my slides. We're going to, of course, talk today about the new juvenile law that took effect on January 1st of this year. Which included lots of changes to how juveniles are treated in the capacity system. I'm going to be talking about the evaluation and report requirements and the credentialing procedures. And then Peter's going to jump in halfway through and talk about the remediation process, or as it's called in the adult system, restoration process. So let me see if I can get my slides to work here. 1 second. Whoops. Oh, sorry. Apologies. It worked a moment ago. Here we go. How about this? Can you all see that okay now?
Not yet.
No.
No. Okay. Hold on. Let me try one other option. What about that?
Still not showing on my screen.
There we go. How about that?
Yes.
Yes.
Yeah. There you go.
Okay. My apologies. I thought I was technologically savvy enough, but apparently not. Whoops. Go there. Okay, so anyway, the law, as I mentioned, took effect in January, even though it passed some time ago. And one of the biggest changes to the statute deals with the definition of incapacity. So many states for some time has really identified and recognized, I should say, the difference between adults and juveniles. And they have changed their statutes. And North Carolina finally caught up, to be honest. You know, for a long time, we've used the adult standard with kids, and sometimes that's not applicable. Most notably, here's the definition. I won't read it to you, but most notably, states have introduced this idea of developmental immaturity, which the new law in North Carolina also recognizes, because there are some juveniles just simply, not because they have a mental illness, mental disorder, or whatever term you want to use, but they simply are not able to proceed in their case and work effectively with their attorney because they're just not mature enough. They're not old enough. You know, an 11-year-old, a 12-year-old, for example, just doesn't have the life experience, the brain development. So the statute really recognized that an individual could be, a juvenile could be incapable to proceed simply because of that developmental immaturity. Previously, it was, you know, if you had a young person who was capacity was questioned, that individual, if they didn't have a mental disease or defect, they technically should go forward in their case, right, or found capable. But many times we've found these kids simply didn't have the functional abilities to work as a capable defendant. So the statute, the legislatures really did not just a definition change, but in terms of the evaluation procedures, they're really laid out in significant detail. I don't know if any of you have reviewed the statute, but it's a lot more robust than the adult statute, which needs some work as well. But one of the things they recognize is they didn't want these juvenile evaluations to be screening evaluations. For those familiar with the adult system, we have sort of a two-tiered process or procedures. One is an adult could get a local evaluation, which are identified as screening evaluations. They're typically shorter, you know, they're not as extensive as, for example, an evaluation by a private examiner or someone at Central Regional Hospital, where those assessments also take place. But the General Assembly, you know, decided, hey, we want these to be, there's a lot at stake, especially for kids. We want these to be what they refer to as full examinations. And I provide the definition here, but part of that full examination is not just interviewing or speaking with the juvenile, but there's a requirement that you review, the evaluator review, all the available, you know, records, like medical records, educational records, and so on. And furthermore, not just review of records, but if testing is indicated, testing needs to be done, whether it's IQ testing or other developmentally appropriate tests for the juvenile. Again, with this idea that these are full, more extensive evaluations, not screenings. Now, oftentimes because, or I should say in most cases, because the statute now requires that psychological testing be at least considered, the majority of the credentialed folks, and we'll get to that in a minute about who those individuals are going to be psychologists. And if they're not, if they're psychiatrists, for example, it's going to have to be you know, someone who can consult with a psychologist when that's indicated. Unlike the adult process, though, these, at least for now, are not going through the LME MCOs. So the courts are going to directly hire these individuals identified as credentialed to conduct these assessments, and not, again, have the LMEs pay for or monitor or oversee that system. So it is distinct from the current credentialing. Right now for adults, not only is there an initial training and credentialing, but there's also annual training that's required for folks. With the juvenile system, as we'll get into here in a moment, the standards are much higher, but there's not that added requirement of annual training. Now, this last bullet point is almost going to be removed soon enough, because the statute indicated that if someone had been doing these juvenile evaluations, they had 12 months before they needed to get the credential. Well, that clock expires next month in October. So essentially there'll be no grandfathering, not that anyone has requested that or done that, but that will expire here very soon. Some other elements of the evaluation process. First and foremost, if the individual committed the crime or allegedly committed the crime between the ages of 13 and 16, but they're now an adult, this would not apply to them. 15A, the adult standard, their statute would apply. It also doesn't apply with certain felonies, F and G felonies for juveniles 16 and older. In those cases, those are automatic transfers. The evaluation itself must be completed within 30 days of the court order, which may sound like a lot, but again, if you're doing a full evaluation that includes reviewing sometimes extensive records, talking with family members, interviewing the individual, and so on, that 30 days can move by very quickly. After the evaluation is completed, the clock still is on, so to speak, and if it's a misdemeanor case, the evaluator has 10 days, and in felony cases, 30 days to get that report done and submitted. Now, like the adult system, there is the option to have the individual sent to a state facility for up to 60 days for that assessment. The criteria is pretty vague, well, very vague. It says when it's appropriate, but it gives no guidance to the court about what is or isn't appropriate. But be that as it may, if the court does order an individual to a state facility, they will, in all likelihood, go to Central Regional Hospital, where we have credentialed evaluators who would conduct those assessments there. One final element, and there's more to it, and I encourage you to read the statute, of course, but I'm trying to just hit the highlights. But one of the other components is that if the juvenile is under 12 and charged with a crime, the court has an obligation to inquire about capacity. Normally, it's got to be brought up by one of the parties. There's got to be, that motion or inquiry needs to be made, and the court will have a hearing. But in these cases, it's a requirement if they're under the age of 12, which makes sense, right? If you're under the age of 12, there's a very high likelihood that you're going to have trouble working with an attorney, understanding the case, understanding your constitutional rights, all the elements that are needed to be a capable defendant. In terms of the evaluation itself, the court also, again, as I referenced earlier, really lays out a lot of detail about what that evaluation should include. And this models a lot of other states, like Florida, for example, where if you read their statute, it is very detailed, multiple pages about what is required in the evaluation and the report and so on. So a little bit of that was copied, so to speak, into our statute, which I think is a good thing. But one of the requirements is obviously you got to determine, the evaluator has to determine if the kid or juvenile is capable or not, and if they'll be able to attain capacity in the foreseeable future. The second component is what is the basis for that incapacity. That has to be explained. And then there are 8 functional abilities that specifically have to be addressed. So if you're reading a report from an evaluator and you're not seeing these elements, then that might raise some red flags. But the evaluator should be addressing each and every one of these. For example, the juvenile needs to appreciate the charges, what the consequences could potentially be, who the people are in the courtroom. Are they able to disclose and share information with their attorney and testify relevantly if that's indicated? And importantly, can they make reasonable and rational decisions? So all of these are elements that have to be addressed. There is a catch-all category. I don't know if that'll be used much, but if there are any other factors the evaluator believes is important, included in the evaluation as well. Now, in terms of the report or not the elements, but the structure, these 7 items have to also be addressed. The referral question needs to be in there. The notification, and by notification, I mean the evaluator has an obligation to notify the juvenile what the purpose of the evaluation is, what the report, or where the report, I should say, is going to be submitted, who's going to see it, and what the limits of confidentiality are. It's not like a normal doctor-patient relationship. They need to be told, this isn't something that can be kept private between the two of them. This information will, in all likelihood, get shared with the attorneys and the court, and possibly others. The procedures that the evaluator used need to be listed in the report, as well as the sources of information that were used, whether it's police reports or, you spoke to the mother of the child or whatever. All that needs to be outlined in the report. Obviously, considerations, what the evaluator considered, and his or her findings and observations need to be included as well. Again, part of this overall package of being a full evaluation. One should not be receiving a 1 or 2 page report. Again, that would be a red flag in my mind, because there's just much more that needs to be included in these assessments. But all that needs to be in there. And courts, again, another catch-all, the court can request other things be addressed in the report. I don't know what those would necessarily be, but there's that leeway courts have, or that ability they have to sort of ask the evaluator, if he or she can answer the question, to answer those additional questions. Now, Peter's going to get into what happens if someone's incapable, but in terms of the report itself, the evaluators need to recommend treatment or remediation, education, whatever term is needed, but recommend what is needed to get the individual to a place of being capable to proceed, and what is the likelihood that they'll get there in the foreseeable future. Now, what is foreseeable future, you might ask? I don't know. I don't have an answer to that. I don't know that anyone does. It's not defined. I doubt there's any case law, none that I'm aware of anyway, that define that or explain that further. But that opinion needs to be provided. Also, thirdly, how long will it take to get capacity? If you have someone with severe impairments, brain injury, for example, the evaluator might conclude it'll take months, if not years. Or in other cases, depending on the illness, the disorder, or whatever is present, that duration could be a very short period of time. So it'll depend obviously on the clinical presentation and what the evaluator concludes, but that element about duration needs to also be included in the report. The final piece is a little bit trickier. It also says the evaluator should offer a recommendation for the least restrictive environment for remediation. Now, in some respects, this is basically asking the evaluator to conduct a risk assessment in some ways. And I doubt that you're going to see a full-blown risk assessment in these capacity to proceed evaluations. My prediction, or my guess, is that most evaluators will indicate to the court, hey, this person could get outpatient services, they could get restoration, where Peter and his, the folks he oversees, provide it, or mediation, excuse me, if the court were to release them on bond, or if the person is kept in custody, here are the options there. So it's gonna be an if-then sort of explanation, I think you'll find in most cases, whereas it is not going to be a full-blown risk assessment where they're going to inform the court that, hey, I think this person should stay in custody or not because they're a high risk or a low risk. I think you're going to see discretion given to the court, but just explaining or educating the court about the various options at the different levels. I'd be curious on people's thoughts about that, though, or if folks have questions. That one's a little bit trickier in terms of the requirement for evaluators to address. So moving on now, so that's what's required in the evaluations and the reports and a little bit of the procedures, but DHHS was, in the statute, was required to develop the standards for someone to become a juvenile capacity to proceed evaluator and the credentialing process, and we've done that. My office has set up a credentialing body that reviews applications on a monthly basis. And we go through to see if the individual does meet the criteria and should receive, credentialing. We then notify them, they get a certificate, of course, and then their information is posted on our DHHS website, where anybody can find, and I have a link to it here at the end. Anyone can find that list of individuals, and I think we have 25 on there now, who have gone through and are credentialed to complete these court-ordered capacity to proceed evaluations. And I should mention that, the law made clear, defense attorneys, prosecutors can always, hire their own private examiner, who does not have to go through this process. But for court-appointed folks, they do. So some of the things we look at are some of the standards that we've set and we're looking at when they complete and submit their application is, one, do they have a valid North Carolina license in a mental health field? Do they have experience conducting capacity evaluations? Not necessarily with juveniles, but do they have, broadly speaking, that experience? And if they worked in other states, they call them competency to stand trial in many other jurisdictions. We're looking for that type of experience, not necessarily North Carolina capacity evaluations. We also need to make sure, and they need to demonstrate that they have experience with the psychological tools needed, with knowledge in child development, and various methods about how to assess or evaluate juveniles. So all that experience they need to demonstrate. And they do it by these factors or through these methods. One is they share a cover letter. They submit and upload a cover letter describing their experience. They share a copy of their license and their curriculum vitae so we can go over, so the committee can go over and review that and verify that they have the necessary background experience and so on. And then we have them submit a sample redacted report that they've recently completed. So we can actually see their work, see how they, sort of analyze and describe and evaluate and report on an individual. Again, just to make sure they meet the standards that we require. And then if there's some questions or uncertainties, we can always ask for additional information or clarification, which we've done on a couple of occasions. Again, just to ensure that these are top-notch quality, folks who have the types of experience needed to do these evaluations. Now, if someone is denied, if they have applied and denied, it doesn't mean they're denied forever from getting credentialed. We do have a process in place that they can reapply after they've gotten the experience or demonstrated that they meet the standards. However, if someone's license is suspended or revoked, they automatically lose the credential to complete capacity to proceed evaluations for juveniles. Here is the link, which I encourage you to go to our website, but if you click this link, it'll go there and it'll describe a lot of the things I've talked about today, but also has an Excel file you can open up and you can see where all the credentialed individuals, their contact information is, and it's updated on a monthly basis. Again, we review these every month, so if anyone gets added, that gets updated, so you'll have an up-to-date list and a way to reach them. I want to comment on one other situation that we've encountered recently. Currently in 7B2401, it indicates that the court is to pay, following the AOC recommended guidelines, these credentialed evaluators. Now, we've run into a bit of an obstacle because the Administrative Office of the Courts has really pushed back a little bit and indicated they don't have the funding or they're not able to pay and are not paying these credentialed evaluators. They, as a result, have pushed for an amendment to Senate Bill 257, which is the finance bill, basically, the Appropriations Act, which has not passed, but at some point I suspect will pass. Whether this provision and how it's written goes forward, I don't know for sure. So I'm a little hesitant to talk about proposed laws, but the problem we faced is that AOC's indicated they're going to wait to see what the new law says, if anything, but they're currently taking the position that they're not going to be paying for these. So what has happened is on occasional or, a couple cases, that I've been, heard about when speaking with the evaluators, the county will pay or the prosecutors have paid on a few occasions. In Mecklenburg County at the Forensic Evaluation Unit, they have a contract with the court, so they've been doing these, but most of the evaluations are sort of on hold because the credential evaluators, they're not getting paid for this, so they're not inclined to take a case, right, until this gets clarified. So we may get clarity when this passes, or if it passes, Senate Bill 257. But part of the problem, as I see it anyway, is that the current version of that, which you can all pull up and see for yourself on the General Assembly website, but the current version indicates the LMEs are to contract with the evaluators and pay them, but it doesn't require them to pay at the AOC recommended rate. Well, we've had a historically difficult time with the LMEs paying the adult capacity evaluators a fair and reasonable rate. And if they don't pay, at the AOC recommended rate, my fear is we're not going to have any evaluators who are available to do these court-appointed evaluations. So we'll see where things, land here in a bit. Maybe the LMEs will have pressure at some point to pay at a higher rate. And the current rate, by the way, that AOC recommends is not all that high for people with, for doctoral level psychologists, especially those with juvenile experience. It's between, I think, $200 and $220 an hour. But that compares to, roughly $200 per assessment for adult evaluation. So they're not going to be able to pay that rate and be able to hire any or contract with any evaluators. So I'm a little concerned, but I think it'll all get worked out in the end. But I wanted to share this, so if folks are having cases come on, in front of them, or have current juveniles they're working with, that this could pose a bit of a problem depending on where you're located. All right, I think that's my apologies. I couldn't see. I was blocked from seeing anything in the chat or questions. So if anything came up regarding what I just shared, Yolanda, maybe you can. I can field it now, or we can field it after Peter talks. But was there any burning questions that came up?
There is a question that just came up by Marcus Jackson. He says, when the juvenile is found incapable by the evaluator and they recommend education that is not available in your area, what is the defense attorney's next step?
Well, Peter will talk about that. There has to be. There is. Juvenile justice has that burden of finding and providing the service for anybody found incapable. But I'll let Peter get into that. I don't know if you want to add anything now, Peter, or just wait till you cover it.
That is actually the crux of the question, Mark, is that for remediation, and we're gonna look at that. We're gonna look at the remediation structure, and that is that psychoeducation portion of the work here. So yeah, we'll cover that.
I think that's all for now, Dr. Cochran. There was a question about a re-entry simulation, but I think Dr. Coons and Eric have handled it in the chat.
Yeah.
Great. Well, I encourage folks as Peter's talking, if you have other questions about the evaluation credentialing process that come to mind, put them in the chat and we'll cover it at the end. Thank you, Yolanda.
I'll turn it over to you, Dr. Coons. If you need any help sharing or anything, just let me know.
Okay. Well, thank you so much for allowing us to come on and talk about this issue. That I'm Peter Coons, and thank you, Bob, for kind of starting this discussion off. That I do have to point out that that Mary Wilson is also on this call. That Mary Wilson basically wrote most of this legislation. That I was privileged to be on this work group. Where we had a multidisciplinary work group of subject matter experts that Billy Lassiter, the Deputy Secretary of JJ, asked me to lead a work group, and I on capacity and juvenile capacity to stand trial. And I said, that's great. I think he assumed that I'm a psychologist, so therefore I have an expertise in juvenile capacity law, which I do not. But I learned a lot from lots of experts that we got to sit on that panel. Mary Wilson was also a godsend when she was able to put these thoughts into writing, and we were able to kind of craft a lot of language. So really good to be here. I know that we also part of that work group, we had Eric, that Eric was on the call and on the work group, and several others from this group. So really good to be back. I'm going to share kind of where we're at. Let's see if I can do this, Yolanda. Let's see, kind of work this out. So let's see if this works. All right. Are people able to see that? And yes. I cannot see you, so if you can just tell me.
We can see it.
All right, cool. All right. So North Carolina juvenile capacity remediation, that Bob did a really great part about talking about the legislation, talking about the requirements for the evaluators. What we really wanted to do is we wanted to set up a process to say that to really make sure that it is not just saying that individuals that are trained in the adult system, that understand the adult capacity model, are all of a sudden experts in juvenile cases as well. We wanted to say that there needs to be specific issues and specific training that has to be different because juveniles are different, that we understand that. That's why we have a juvenile justice system. That's why we have, juvenile defense attorneys, is because juveniles are different and law is different. And so we needed to set this up. That if you remember several years ago, prior to us having this, we had one standard for North Carolina. It was a adult standard. And it basically stated that you would lack capacity for really mental illness or mental defect. And so the problem with that, of course, is that that we would have individuals say that we have an 8-year-old or a 9-year-old that is legally able to enter into the juvenile justice system. And several judges would talk about this. They said, that this kid still believes in the Easter Bunny, and we're putting them in court and expecting them to understand the entire complex judicial process. And so that there was a lot of problems, that the kid was not mentally ill. And so therefore they were legally bound to go through the court process, even if they don't understand what is going on. And so we're trying to make some legal language to state that we want to protect those kids, and really making sure that it is necessary to assess that individual's level of maturation and maturity to understand the legal process. So this is a really nice handout that Yolanda, that I sent Yolanda about 5 or 6 different handouts that hopefully you guys will get a chance to receive them in the email. If they're not able to be sent out, I'm certainly happy to send those out as well. But this is a nice handout that has just a nice picture of what the juvenile capacity to proceed procedure is. And it's cut off at the bottom a little bit, but this is kind of just, it's a fairly complex looking thing, but this is a nice 1-page description of what is going on. So that Eric already talked about this, but of course that we had this became effective. This new law became effective for offenses committed on or after January 1st, 2025. And it was only effective and only pertained to juveniles with petitions to juvenile court. This was the House bill. It was introduced in House Bill 186. It's NCJ as 7B 2401-2401.5. And so, what is that? It is juveniles with petitions to juvenile court. The court is motioned, questioning the juvenile's ability capacity to proceed. A forensic evaluation is ordered by the court, and that's where Bob and DHHS come in, is to make sure that those forensic evaluators are the appropriate evaluators to appropriately assess kids. Then we have a juvenile evaluation conducted, and the report is submitted to court. The judge determines the juvenile does or does not have capacity. It is important there that number 4 to remember that the juvenile evaluator, the forensic evaluator, does not determine capacity. That capacity is a legal precedent, that it is a legal decision about whether this juvenile has capacity or not. And then number 5, the judge may determine juvenile does not have the capacity now, but may have the capacity in the foreseeable future. And of course, Bob, mentioned that's kind of, ambiguous language there about foreseeable future. But if there is some determination that yes, this juvenile does not have capacity, but may have capacity at some point in the near future, the judge may order the juvenile to remediation programs. We decided on the terminology of remediation rather than the adult language of restoration. That is probably the most common language when it talks about juveniles, and we're talking about remediation rather than restoration. Restoration is really assuming that those skills and that knowledge was previously there. But remediation is really what it truly is with the majority of these juveniles, and that is learning. It's learning sometimes for the very first time about what is court, what is this process, what is the law, what is the juvenile law, what may potentially happen to you. So what is remediation? It's a new program model in North Carolina. It's implemented in other states by different agency types. Comprises one or two remediation components. One is that you may have mental health treatment and or a psychoeducation program. It delivers instructions, aims to help juveniles gain capacity. It's an online curriculum. And we will have a pre, a during, and a post program test to see how that juvenile is doing. The program model, it's didactic. It's structured as one support specialist with one juvenile, so it's a one-on-one setup. It is in person. We are really trying to conduct this in the least restrictive environment, and so that is going to be based on what the judge states, and of course we have to take into factors such as safety, the nature of the charge, but so that it is possible that we may conduct these curriculum classes in our juvenile detention centers. It might be conducted in a hospital. It might be conducted in a school. We would prefer it in a least restrictive environment, such as a home, that like other types of community settings. So other web-based curriculum, it is 10 modules long. It teaches the juvenile about the court system. It talks about, what are the different people in the court system, the court actors. It uses animated videos. It's carousel. It's very kid friendly. It's interactive. It has interactive games. And so the kids can learn through games than through learning. It's in module knowledge checks and module tests. The dosage is about 1 to 2 sessions per week, maximum of 1 hour per session. And if you fail twice with a modular test, we will go on. So it's not like the process stops. We will, if you fail it once, we will go back and we will do it again. And if you fail it twice, we will continue the process with the kid. The development timeline was we advertised for program provider applications in December through January. We did award. The provider award announcement was for Methodist Homes for Children. So they were able to pick up the curriculum and the work. And so we do have one statewide provider that is providing our remediation work throughout the state, and that is Methodist Homes for Children. They have multiple offices throughout the state. They've been partners with juvenile justice for quite a while. They have residential centers, they have community-based centers, they have home-based centers. And so they were just a natural partner for us. We gave a provider training on February 17th and 18th. We launched the curriculum on March 1st, and the program started on April 2025. So what are the timeframes that the legislation talks about with remediation? So after the forensic evaluation is submitted to court, it has to be done that once the forensic evaluation is ordered, as Bob stated, it has to be done within 30 days. It has a possibility of being extended 2 times for a maximum of 120 days. Then the capacity determination and remediation programming is ordered. That is an order by the court. And once the judge reviews that and states that, yes, that this individual has the potential of regaining capacity within the foreseeable future, that they have the option of ordering remediation. Within that within 14 calendar days, the juvenile court counselor has to send a referral packet. So on top of every evaluation that is conducted, that the evaluator is really supposed to include this cover sheet. And this cover sheet is really due to the fact that the individuals that are reviewing this are not going to be licensed psychologists. They are not going to be forensically trained. And so the evaluator can hopefully break down what the contents of the evaluation is. Really just what is the nature of that this evaluation supported the opinion that the juvenile named above is capable to go to trial, at which point we would just continue on with the process. Incapable to proceed to trial with no ability to attain capacity in the foreseeable future. At that point, the case would be dismissed, and all charges and all work with juvenile justice would be stopped. The third option is, what we have been talking about, is that incapable to proceed to trial with an ability to attain capacity in the foreseeable future with remediation services. And if that box is checked, we continue on. That then it says, what is the reason for the incapacity? And this is where that legislation really kind of gave a lot of leeway. It stated that if you look at the legislation prior to this and the standard prior to this, there was only two options. It was either mental illness or mental defect. We included mental illness or mental disorders. Intellectual disability is an option. Neurological disorders, traumatic or acquired brain injury, and then developmental immaturity. Then we talked about that the evaluator will then recommend what is the level of service that should address this capacity issue. So whether that's psychoeducation, that's going to be the remediation curriculum that we're going to further talk about. It might be mental health therapy, psychiatric evaluation for consideration of psychotropic medication, could be a court order to be assessed for involuntary psychiatric commitment. Then it continues on to state, that we are anticipating that this treatment will take X amount of time. And then we are asking the evaluator to make a determination of what is the least restrictive environment. But Bob is absolutely correct that, that if we're not going to be doing a safety check, on these juveniles, then you're making your best guess. You're making your best guess with that. The remediation program referral is that within 14 days of receiving the order, the juvenile court counselor will complete a referral packet. The referral packet must include the following. It's the juvenile court counselor's supervisor name, universal referral form, the court order and or the forensic evaluation cover sheet, the family data sheet, the YAZI pre-screen, and the multi-party consent form. That consent form allows us to communicate between the provider of the remediation services and juvenile justice and the court system. Gives us permission for that. Within 7 business days of the referral being received, the Juvenile Community Programs Contract Administration Team will respond with a decision whether it's accepted, whether it's deferred, or needs more information. So there may be some cases where we receive a packet and there's not enough information on there that we need to go back, make sure that it is crystal clear how we're going to approach this situation. Accepted referrals shall be immediately sent from community programs
There may be a connection issue with.
Did we lose Peter?
Yes, we did. I think there may be a connection issue. Hopefully he will.
And we had a lot of, and Mary will tell you, this was a source of a lot of debate.
Hey, Peter.
And
Peter,
there were some compromises. Was there a question?
Sorry, you got cut off there for a minute, and we lost your slides. I don't know if you want to put them back up.
Oh, okay. They're still showing on mine. So let me see.
So you're not seeing anything right now?
No, you got
Okay.
kind of
All
booted
right.
off of the presentation for a minute.
Okay. That's weird. Let's see. All right. How's that?
Yep, there it is.
All right. This is a pretty important slide. And that Mary Wilson will be the first one to tell you as well that it was very interesting process when we were writing this legislation. We had a lot of different parties on here. We had the prosecution, we had defenders, we had subject matter experts, we had judges, and we were trying to figure out language that made everybody happy. And that was difficult. And so one of the compromises that we stated was that the length of capacity remediation work would be dependent upon the charge in which the juvenile was potentially going to be charged with. The length of allowable time. And so there is a 36-month maximum period. And so that the most serious charge that the juvenile can be held up to 3 years in the remediation curriculum phase. And this is going to be reserved for individuals that are charged with first-degree murder, first-degree forcible rape, first-degree statutory rape, first-degree statutory sexual offense. Then you have another category, which is that 24-month maximum period. It's 12 months plus good cause for another 12-month extension for B1, B2, C, D, and E. And then there is another group, which is a 12-month maximum group, which is 6 months plus a good cause of another 6-month extension for F, G, H, I, or misdemeanors. And so that is the maximum length of time. That is different than the adult system. The adult system is really, I believe, it is up until half that sentence that you would receive if you were charged with that crime. It can be up to 10 years. It can be longer than that. Then I remember certainly when I was working at Central Prison, there were individuals that were held for years and years and years waiting for restoration work. So that is certainly a possibility. That remediation program begins with the support specialist beginning the family engagement and curriculum. There is an obligation that they present to court every 90 days on the progress of the youth. And then once there is program completion, that the program specialist is obligated to notify the court within 2 business days. So let's look a little bit at the curriculum itself. That we adopted this, that when we were going through this, that we adopted this from the Utah system. The Utah system had a really nice curriculum. It was also free, which is also very nice. So the Utah Department of Health and Human Services had put together a juvenile capacity remediation work, which we adapted. The goal of this, of remediation, is really to improve the factual understanding, rational understanding, and ability to work effectively with their attorney. So with you on the call, that their ability to be able to work effectively with you. As we had previously stated, it is interactive, it is online, it's didactic in nature, it's modular. We have a assessment for each module, and variety of content types, including animated videos, images with clickable call downs, drag and drop sections, matching and card sword types of questions, interactive scenarios, flashcards. We have 10 modules that every juvenile will go through in a sequential way. It will not be that a juvenile starts at, say, module 4, because we know that they have already completed module 1, 2, and 3. everybody will start at module 1 and go through the entire process. And so as you see in here, getting comfortable with remediation and my provider, my attorney, the prosecutor, and the judge, the juvenile justice system. What am I charged with? What could happen to me, my side of the story, working with my attorney to tell my side of the story. How do I defend myself, testifying, and how do I act in court? And it's really designed to be very kid-friendly. So you will have child actors' voices that will be talking through animated videos where they will be going through different scenarios on explaining the court process, explaining the juvenile justice system. And then there will be card sorting activities where a juvenile has to move this card over to the appropriate box to be able to move through. And so it's designed to be very user-friendly. There is confidentiality that is built into this process. We understand that a juvenile, being juveniles, that they may come into the process and state, even if we tell them not to, and the evaluator and the support specialist tells them not to do it. We fully understand that juveniles may come into these hearings and fully admit to the crime, fully admit to what they are being charged with. That we included a statement of confidentiality that stated no statement or disclosure made by the juvenile during the remediation services regarding the juvenile's responsibility for a criminal act that can result either in a adjudication of delinquency or transfer of a matter to superior court for trial as an adult is admissible in any juvenile or criminal proceeding against the juvenile or defendant. All remediation progress reports, summaries, and notes shall not include any such statement. So that is indeed to protect the process and to also protect these juveniles as well as the evaluators, as well as the support specialist going through it. All right. I was able to, I'm going to try to get back here and see if I can figure out how to do that. All right. So that was my presentation, and I was not able to see, as Bob wasn't, whether there was any questions or not.
There are 2 questions in the chat. There's one from Chris that says, does the presence of TBI lead to a presumption of incapacity? And then I can read the second one after you all address that one.
I would say that like Bob can probably answer this better, so I will defer to Bob. But.
No. We might say similar things, different things. I don't know, but I'll jump in. And Peter, please also share your perspective. I would say the answer to that is no. Not because the TBI isn't important, but at the end of the day, what really matters is what a defendant, juvenile in this case, can or cannot do, what their functional abilities, as the term is often expressed, are. Can they work in their defense? Can they understand the charges? Can they, rationally make decisions? That's what's important. It doesn't matter what the diagnosis is in many respects. It really doesn't. It can dictate what kind of treatment the person gets and so on. But I wouldn't presume anything based on any diagnosis, any illness, any TBI. Obviously, if you find out your client has a TBI or history of mental illness, you should explore that. And if you're having communication problems or any kind of issues, then yes, the obligation is to raise the issue. Peter, what do you think?
Yeah, I would completely agree with you, Bob, that it's the same as anything else. The presence of mental illness does not necessarily state that the individual is going to be to lack capacity. That lots of individuals with mental illness certainly understand court processes. Lots of individuals with TBI understand how to conduct themselves in court, understand law. The lots of underage kids would be able to demonstrate that they understand law and understand how to, conduct themselves in the courtroom. So all of these things have to be evaluated, and all of them have to be scrutinized with the assumption that the juvenile does have capacity until they prove us wrong.
Thank you both. The second question is from Kim. She says, you mentioned that if a youth fails a module 2 times, they move on to the next module without passing the previous module. How does that impact the remediation process?
Yeah, so it will continue on, and it is not really a pass or fail. And so remediation really isn't designed to be a pass or fail. It's designed to provide the education, and to also, once they get through that process and they get through all 10 modules, they can be re-evaluated. So they can be re-evaluated by the forensic evaluator. And the forensic evaluator will state whether this education has been enough, whether they've met the criteria or they have not met the criteria. So it's not necessarily a pass or fail. It's designed to provide the education, and then to see whether that has met the criteria or not.
There's a question from Eric that says, what has been the biggest challenge, except for funding, so far in implementing the new process?
Well, I talked about our biggest challenge, and that is credentialed evaluators getting paid. There's a bit of just a different perspectives on that, and until we get some funding clarity, it's going to remain sort of a challenge for folks who need to get these for court-ordered assessments anyway to get done in North Carolina. Peter, I don't know, what do you think?
Yeah, it's a hard question, Eric, when you take out the funding, because funding is number 1, 2, 3, 4, 5, 6, 7 of this whole process. That this was essentially a unfunded mandate, and so we worked on this for a number of years. We stated that this was not going to be possible. Mary certainly remembers that, and Eric and the others that contributed to this. We stated this was not going to be possible without funding from the legislature. We received no funding. We have not received any funding yet to be able to work with Methodist Home, to be able to provide any assistance with the evaluators. And so that's been a frustrating process. I will say right now that we have one youth that is in remediation, that is going through the process. We have numerous youth that are waiting to go into the process, but that the lack of evaluators, and evaluators rightfully saying, we've had several evaluators that have conducted 1 or 2 or 3 evaluations and have still not gotten paid for that. And you can assume that people are not volunteering to do this. This is not out of the goodness of their heart, even though that they would love to do this and they feel passionate about this work. They also need to pay for their families and support themselves. And so, yeah, that's been I would say that's the biggest challenge. I think overall, I have not seen resistance from this. I think people are genuinely excited about the change. Even the most conservative members, when you talk to them about there's a difference in juveniles, most people agree with that. Most people agree with that there's a difference in the juvenile mind and juvenile brain, and it needs a different standard.
I might add one thing before you move on, Yolanda. We don't really know yet what the supply or the demand will be, excuse me, in order to determine the supply, the number of evaluators. As I mentioned, we have about 25 evaluators. About 5 or 6 of those are in our hospitals. So we really only have about 19 or 20 to serve the state otherwise. And we don't know if that's enough. I assume it's probably not enough. We're going to need more evaluators. We got a good application over the first few months. A good number of folks applied, but now that's trickled off. We're not getting very many evaluators apply. So I guess I don't know if it'll be a challenge for us or not, but I worry that we won't have enough evaluators if the demand goes up over the next few years. But time will tell, I guess.
There's one more question from Mary. She says, will the kid's family be charged anything for the program?
Yeah, no, that this is all state funded. State funded, I'm putting quotes because we have no funding, but we are using state money to be able to provide this. And same with the evaluators and the evaluations, is that that it is written that now, if a child's family wants to have their own private evaluator, they certainly can. And there is some language in the legislation that allows for that. But the majority of the kids that we are going to be serving, this will be provided. All the services will be provided for them.
There aren't currently any more questions in the chat, but please feel free to unmute yourself and ask any additional questions if you have any.
I see Eric has a question I'd like to try to tackle. What could juvenile defenders do to help their clients? I would say stay in touch with the providers and stay in touch with the evaluators. A lot of times what I hear for the adult system anyway is our providers and evaluators try to speak with the defense attorneys, try to get their perspective about their interactions with their clients, not confidential privileged information, but just, hey, how are your conversations going lately? He's been getting treatment for a few months now, and does he sound better to you? Because that kind of feedback helps with the decision-making process. So I would say one of the things you could do is to stay in touch with those providers and the evaluator.
Absolutely.
I have a question about for the youth that would be in the remediation process for that maximum time, that 36 months. Would they do the full 10 modules in that 36 months? Would it be some repeating of the program if they have done it, the program, say, once through and they are not remediated? I guess how would that time period impact how they go through the modules?
Yeah, that's actually a really interesting question, and of course we have not had to deal with that yet because it's fairly new. It's a little tricky. So in the packet, Yolanda, that I sent out, there's multiple handouts. One of them is a really good article by Jackie Green on juvenile remediation throughout the country. And she breaks down the North Carolina legislation in a really nice way, and then also talks about remediation through the country. What we find, particularly in the cases where it's maturation issues and developmental maturity issues for juveniles, we find that these kids will meet the criteria fairly quickly. It's fairly rare that a juvenile will need more than 3 months to 6 months of work to be able to meet the criteria for capacity to stand trial. You also know fairly quickly if a juvenile is not going to be able to meet the criteria. So it's a little tricky when we're thinking about this and saying, there is a potential of being held for 3 years. I could see going very slowly through the program. I could see maybe going a couple of times through the program. The job of the specialist, the remediation specialist, is to determine, say, this youth has completed the requirements of this program, refer that back to the evaluator. The evaluator will then say whether the juvenile has met the capacity criteria or not, and still send that back to court as quickly as possible. So that is the job, is to send as quickly as possible when this youth has finished. The judge then has the leniency and the ability to say, I'm not ready to turn this kid loose yet. Because of the nature of their crime, I want them to go through it again. And so that's going to have to be a judge's order. We are still going to operate in the juvenile justice program, and the community providers will still operate in the exact same way. We will try to get this kid through the program as quickly as possible. And we will try to refer that back to the evaluator. We're going to have to leave that to the judge. And the judge then is going to have to say, do it again, or, some other type of treatment plan to be able to extend that time.
Thank you. There is one question from Terry. She says, for remediation, what controls are in place to make sure aren't simply parroting back information presented to them?
That's
Bob,
a
you want
great.
to talk about the evaluator?
Yeah,
and how
that's a
they
great
answer
question,
that?
Terry. I get that or have heard that issue raised several times, and it's a valid one. So first and foremost, the evaluators are trained to discern when someone's just parroting back something versus have an appreciation, understanding of it. One of the little ways they do that is, have them explain something they've been taught in their own words, have them use examples, So there are methods that, interview methods that the evaluators are trained to use to ensure that it's not just a repetition, someone just, saying something they heard from an instructor in a remediation course. So that's the main control. The second control is litigation, right? If you suspect that, oh, my client, he really doesn't understand, he's just saying all the right words, or she's saying all the right words. Well, then you question that examiner during cross-examination, right? You force that individual to explain how they determined this wasn't just parroting, but this was an actual understanding that the child had according to their opinion.
Thank you. Those are all the questions in the chat. Eric did post the article from Jackie Green. Thank you, Eric. Again, please feel free to take yourself off mute if you have any additional questions for Dr. Cochran or Dr. Coons. I don't see any at this present time, but I will just end us for now. I wanted to thank you so much, Dr. Cochran and Dr. Coons, for taking the time on your Friday to teach us about these updates and the procedures. I will send out both PowerPoints and the materials that Dr. Coons referenced after the training with our link to our evaluation. If you do not mind filling that out for us, that helps us just plan our trainings in the future. But thank you both so much again. We really appreciate the time and teaching us on this Friday afternoon. And thank you all for being here.
Very
It's
welcome.
been a pleasure.
Thank you so much.
Thank you. Yeah.
You all have a good Friday. Thank you.
Thank you. Bye-bye.
Bye.